if you do that, if you apply the receipt. Processing information. Any application that is not signed or is not accompanied by the correct application fee will be rejected with a notice that the application is deficient, and that is a bummer. You may correct the deficiency and resubmit the application. An application is not considered properly filed until accepted by USCIS. That's true. Initial processing. Once an application has been accepted, it will be checked for completeness, including submission of the required initial evidence, the stuff that we just talked about, all that initial evidence. If you not completely fill out the form or file it without required initial evidence, you will not establish a basis for eligibility, and we may deny your application. Okay, we're not talking about rejecting. We're talking about denying, okay? No second bite at the apple on that. I mean, a lot of times you actually can refile, but you have to pay a whole new fee on that. So, you're going to lose out on your fee. Request for more information or interview. We may request more information or evidence, or we may request you appear at the USCIS for an interview. Right, well, I got news for you. Based on this marriage to a U.S. citizen, you're definitely going to be called in for an interview, because they want to make sure that the marriage is good. And they also want to ask you questions about who you are and what you've done in the past. Selective service registration. This is important. If you are a male at least 18 years old but not yet 26 years old and required according to the Military Selective Service Act to register with the Selective Service System, USCIS will help you register. It's important because they feel that if you're living here in the United States, you should register for the draft, selective service. That is a moral issue, and so they want you to do that. And so they're saying that, they can help do that. And then they talk again about travel outside the United States for an adjustment of status. Applicants under 209 and 245. Your departure from the United States, including brief visits to Canada or Mexico, constitutes an abandonment of your adjustment of status application unless you are granted permission to depart and you are inspected upon your return to the United States. Such permission is called advance parole. To request advance parole, you must file Form I-131, application for travel document. We've covered that, but they just keep hammering you on this stuff because it's so important. Exceptions. Yes, there are some visa categories here that you can maintain your status traveling in and out even though you have not got I-131 and not have an advance parole. HLV, K3 or K4, refugees and asylees. Then we got this one. We've covered this already. It's just so important. Travel outside of the United States may trigger the 3- and 10-year bar to admission under Section 212A9BI of the Act for adjustment applicants but not registry. This ground of an inadmissibility is triggered if you are unlawfully present in the United States. Example, you remain in the United States beyond the period of authorized stay for more than 180 days before you apply for adjustment of status, and you travel outside the United States while your adjustment of status application is pending. So, remember we talked earlier, we read the instruction where, if you've overstayed your visa, you can still get adjustment of status. So that's why they're putting this notice on it, because if you've overstayed your visa more than 6 months, 180 days, travel outside even if you have advanced parole. You could really get a huge hit. A real bad thing can happen to you, and that is being charged with a 3- or 10-year bar. 3-year bar for over 6 months, and then a 10-year bar if it's been more than a year. So that is a bad thing to have happen. And they talk about the waiver. If you become inadmissible under Section 212A9B1 of the Act while your adjustment of status application is pending, you will need a waiver of inadmissibility under Section 212A9B5 of the Act before your adjustment of status application can be approved. This waiver, however, is granted on a case-by-case basis and in the exercise of discretion. It requires a showing of extreme hardship to U.S. citizen or lawful permanent resident, spouse, or parent, unless you are a refugee or asylee. For refugees and asylees, the waiver may be granted for humanitarian reasons to assure family unity, or if it is otherwise in the public interest. So, you know, they might let you back in, even though you got the 10-year bar to adjust status and get the waiver. They might not. You know, my experience is that a lot of times they just stop you at the border and go, whoa, you got to go, and you can't even adjust status. You have to go to your consulate and do visa immigrant processing. So there's a lot of different stuff going on out there when this happens, but bottom line is that you do not want to travel till you get your permanent residency if you've been overstaying your visa more than 6 months. Okay, I can't make it more clear than that. Penalties. If you knowingly and willfully falsify or conceal a material fact or submit a false document, the Form I-485 will deny the Form I-485 and may deny any other immigration benefit. In addition, you'll face severe penalties provided by law and may be subject to criminal prosecution. It's true, so do not lie. And that's it on the forms. So that was a lot, and I'm so glad that you made it through this instruction, because you're getting the big picture of what's going on. So now's a good time to take a break if you're rolling through this thing, because next thing we're going to do is we're going to go into the actual form itself, line by line, step by step. We're going to dive in there and see what this form looks like and give you what you need to know to tackle this form and get the green card that you so richly deserve. Okay, so now we're ready to move forward with the form. We're back to the immigration forms part over here, and we've gone down to the I-485, back to the page for the form. We're going to download the I-485 just like this. Comes up in Adobe. And up here it says, you'll notice, please fill out the following form. You can save data typed into this form. It might be above the screen capture. I don't know if you can see that or not, but you can save data typed into this form, so that's really great. So you want to make sure you save it before you go back out to check the instructions. And also print out a copy of those instructions. There's that evidence and all the information in there. It's nice to have handy to reference when you're going through this application. So we're going to type or print in black ink. I'm going to type it. I've got my keyboard here, so I'm going to jump right in. So now I've been going through and I've been using a fictional wife of me, Mark Daly, who I'm a U.S. citizen, so my wife is coming in, and her name has been Jane, and I'm going to use caps on her name, and determine her name. You're going to use the name that's on her birth certificate, and the name thing is always, you know, we covered it in a lot of the different areas, but basically name that's on the birth certificate, or you know, any other kind of document that she has that links her name. So it might be a divorce decree, a marriage certificate. She might want to use the name of her ex-husband instead of my last name. So, but here we're going to say that she wants to use my last name, which is Daly, and her first name is Jane, and the middle name is Gomez. And you'll notice that I use caps for the family name, and then a cap and then the lowercase for the given name, a cap for the lowercase for the middle name. That's so that they make sure that they get the name correct. And when the name is all in caps, it's pretty much universal that that's the last name to use. So if she had two different names and we'd put Daly Rodriguez,